How long-term disability carriers may use subjective medical condition limitations in a COVID-19 claim. Hi, I'm nationwide long-term disability attorney Nancy Cavey. I'm here on the Truckee River with my husband Emerson. My husband is a great fly fisherman. Me, not so much. I'm a skier and ski season is over. So he's fishing and I'm talking about one of my favorite topics, ERISA disability claims. Did you know that in your disability policy there may be what I call a get out of jail free gotcha clause that can limit your benefits? It's called the subjective medical condition limitation. Now, if the policy provisions have a subjective medical condition limitation, you ought to read the laundry list of symptoms. It might include headaches, body aches, joint pain, fatigue, and other subjective type of complaints. Now, it's not uncommon for people who have suffered from COVID to continue to have those symptoms, even though they may have recovered. These folks are called long haulers. Now, I'm not really wowed about that name, but that's what people are calling people who have these particular problems. Now, what's important about these symptoms is that they can't necessarily be quantified or established on an objective basis. They're subjective in nature. And that can be a problem for you if your policy has this subjective medical condition limitation, because under most of these policies, they only have to pay you 2 years of benefits if your disability is primarily based on subjective complaints. Well, how do we try to get around that? Well, in part, it depends on the terms of the policy. But there are ways that we can try to establish an objective basis for the ultimate restrictions and limitations. We can do CPET testing, which will measure fatigue levels. We can do cognitive testing. We can even do physical exam findings that show muscle spasm or muscle tenderness. Now, that might or might not work, because many times these policies also will require objective evidence by MRI or CT scan. Well, you're not going to see that in a COVID case. They also may require EMGs and nerve conduction study tests. You're not necessarily going to see that. So the subjective medical condition limitation provision can be so tightly written that, quite frankly, there's really no way to get around this particular provision other than to appeal, and if your appeal is denied, to file a lawsuit, because ultimately these cases will resolve in a settlement. If you have any questions about your COVID-19 claim, call me today at 727-894-3188. Hey, it looks like some rafters have joined this discussion. I'll talk to you later, okay?